Hi, Kak Sigi, are you ready?
Hello. Yes, I guess we can start
Yeah, all right
now,
then.
perhaps.
Okay then.
Thank you.
All right then. So, first of all, again, I would like to ask, am I audible? All good? Since we're online, I have to make sure if it's great, the audio is clear enough for you to hear me. So, good evening, distinguished guests, colleagues, and participants joining us from various places. Welcome to today's Axio webinar hosted by Angraini and Partners. I am Orima Devi, serving as your moderator today. So as you may know, our theme today is how to manage legal shipping risk in the era of global trade war, an Indonesian perspective on trade sanctions. Ladies and gentlemen, in this rapidly shifting global environment, maritime business face complex challenges, particularly regarding compliance with international sanctions and contractual risk. This webinar is designed to provide both conceptual and practical guidance to help stakeholders navigate these uncertainties. Before we start, however, it is an honor for me to briefly introduce our firm, Angraini and Partners. Pak Anggi, if you can kindly share our profile. So, we are based in Jakarta Selatan, South Jakarta. If you can kindly zoom in a bit, Pak Anggi, it's a bit small. All right. So our main service is to provide you with a holistic dispute resolution. And as we wait for Pak Anggi to zoom in on the profile, I would like to emphasize that our firm may be small, but it is heavy-weighted. It is multi-dimensional approach, and we are striving to be a world-class firm. And in order to do so, we have various output and various sector focus. So the first sector focus that is our main team in working various cases or other researchers would be today's webinar, Ocean, Maritime and Climate. And then we have in tourism and trade, technology, and energy. Ladies and gentlemen, our firm is well recognized for its strong expertise in commercial, maritime, and regulatory law. It offers innovative and practical legal solutions for both domestic and hopefully international clients, more international clients, particularly in sectors requiring high compliance and risk management. Also, we provide not only legal service, but also legal insight, which is what we are doing today. Now, we have a very, very special speaker who is someone that I also look up to, and I'm very, very glad to be able to work with her. So today, joining with us as a speaker, we have Miss Tiyana Sigi Pertiwi, SHLLM. A brief introduction on Miss Sigi is that she is both a researcher and a knowledge lawyer. And she is today representing in the ocean, maritime, climate, and trade sector focus. So her work lies at the intersection of law, policy, and governance on the maritime sector, and also the law of the sea, looking at it from the perspective of domestic and also international wise. So she's very good at critical focus at a time when global commerce, compliance, and sustainability increasing overlap happens. Today, she'll be joining us on sharing her insights on the types of legal risk arising from trade sanctions, the Indonesian legal perspective, and how robust contract drafting can help businesses safeguard against exposure. So, ladies and gentlemen, without further ado, please join me in welcoming Miss Sigi to begin her presentation. And Miss Sigi, the floor is yours. Good luck.
Thank you, Ms. Orima, for the kind introduction and also the brief introduction of our firm, Angraini and Partners. We are here today to welcome you in our webinar, ladies and gentlemen, regarding how to manage legal shipping risk in the era of global trade war. This would be an Indonesian perspective on trade sanctions, and we will focus mainly on the legal contractual risk that such policies, such as trade sanctions, will affect your businesses in the shipping industry. All right. can we move on to the next slide, please? Yes, so a bit of an introduction of the discussion that we will be having today. First of all, I will briefly introduce to you regarding the current global trade war and how the economic trade sanctions affect international shipping. And then we will discuss about the key areas of contractual legal risk that we have identified and will be discussing today. And then we will also guide you to identify the type of risk related to sanctions, which may be helpful to you. We will guide you through the who and what of the if there are any parties, cargo or activities in the contract that you have are among the publicly listed sanction list, and how does it apply to you, your counterpart, when to proceed with more caution in identifying the risky and deceptive practices to evade sanctions, and also, last but not least, how contract drafting in Indonesia can help manage this risk. And then we will have a short discussion on a Q&A if there are any. So without further ado, we will start the webinar. So this is just a brief introduction because I assume that these ladies and gentlemen, the participants of today's webinar, you may have heard or touched on the subject of the current situation of the global trade war. And also some of you may be working in the maritime industry already and may or may not be affected by the current situation. So this is just a guide through on so we can be on the same page throughout the discussion this evening. So trade wars could occur when countries use economic measures instead of military force to achieve their goals. And it could occur when one country imposes economic tools or trade barriers, such as increase of tariff for imports or sanctions towards one another. So there are arguably benefits to this modern tool of trade war compared to the full-blown traditional military aggression, naturally. So the World Trade Organization, as in fact, has reported that there are over 1,000 new trade restrictions are imposed since 2008, dwarfing the handful of armed conflicts in the same span. However, there are also risks of this sanction policy backfiring in a globalized economy. For instance, for the average person, the results of trade war could mean that the cost of certain imported goods could cost more due to tariffs. Jobs could vanish when export numbers tank, and also inflation rise as the supply chain flow is hindered. And some countries' income rely heavily on the sanctioned products, such as the case with Iranian oils and their petroleum products, if you know. But deceptive methods to evade these sanctions arises, such as the rise of dark fleet, which is a problem itself, because the trade between the sanctioned entities and all the sanctioned goods uses under the radar vessels, which are often undetectable by turning off or manipulating their AIS system, and use other deceptive practices to remain undetected, such as fake flags. And since they are before the touch of law, then there is a concern if, in addition to the illicit trade, they could also conduct illegal activities along the way, such as oil spillage, illegal fishing, or illegal trades, and then their vessels are way below the marine safety standards. So this is an issue to the maritime industry in general. As we can see, there are a lot of aspects that could be affected by the sanctions imposed by certain jurisdictions internationally. It could mean political effects or economic risk or cultural issues, which could be discussed in such length regarding sanctions. However, but to limit our discussion today, we will be discussing specifically regarding any legal contractual risk arising out of or in connection with sanctions, which may be affecting your business in the shipping industry. And yes, so what are sanctions? Sanctions are a foreign policy to control behavior or others imposed by mostly, more often than not, large countries or organizations to other perceived countries, depending on the purpose of their own foreign policies. So there are two types of smart sanctions or modern sanctions. First of all, they could target specific individuals or entities. On second, border sanctions aimed at encompassing all entities within or activities concerning entities within the jurisdiction of a particular regime. And as far as the shipping industry is concerned, a form of sanctions could mean prohibiting vessels or aircrafts or other means of transportation from entering or leaving ports or certain territory in a country, and then banning provision of providing maritime services to sanctioned entities. It could mean restricting trade in specific goods or freezing assets and disrupting payment flows or travel bans. It all depends on the sanctioning authority issuing the policy. And right now, the major countries or organizations that impose their own trade sanctions with requirements, as we know of, are US, EU, UK, especially now Brexit, and other organizations such as the UN and also other specific states as well. Let's go to the next slide, please. Yes, so recently from the sanctioning authorities from the US, the EU, there has been a trend that that shows that they also target foreign companies in Asia, even if they are operating without the presence of the nationals from the jurisdictions issuing the sanctions. For example, the US OFAC targeting other nationals as well, even though the transactions is without the US presence, which could lead to millions of dollars of fine, violation, or a reputational damage. And as we can see in the guidelines of the maritime trade sanctions issued by OFAC earlier this year, they also had a guidelines on where the high risks of these illicit trades having cargo sanctioned ship-to-ship transfer. Usually they are in high conflict areas such as in the Red Sea or such as in the Malacca Strait, as we can see in this picture we taken from the US OFAC. It's because the Malacca Strait is in between three jurisdictions, which is Indonesia, Malaysia, and also Singapore, and therefore it is likely for these sanctioned trade to have the STS or ship-to-ship transfer of the sanctioned cargo. Here, the example is the Iranian cargo to happen because of the low law enforcement presence because of the shared jurisdiction. And there is also a case that earlier this year that there are several Indonesian oh sorry yeah, can we go back to the previous slide, please. Yeah, there are several Indonesian tugboats that has been put on the publicly sanctioned list because they are assisting the ship-to-ship transfer of the sanctioned Iranian oil in the Malacca Strait, even though these Indonesian tugboats owner or the Indonesian operator has no direct contact with the U.S. persons or any U.S. nationals, which falls under the U.S. sanction list. And also, as we can see in the graphic below, that there has been a rise of the number of designated persons or entities are being put in the sanction list as well. So next slide, please. Yes. So there are general risks to sanction, as we can see, to international shipping, because first of all, the target are very broad. It could target not only entities or individuals, but also specific countries, vessels, and also cargoes. It could also, like the example that we previously discussed, it could also be extraterritorial because of the increasing efforts from these sanctioned entities from these countries to track and penalize non-compliance of the sanction policies that they have. And therefore, it often disrupts vessel operations, cargo movements, insurance and payment flows in some cases as well. And there's also an issue of overlapping regimes of sanctions of authorities, especially in the case of where there's a multinational company or a bank operating in several jurisdictions, which each country applies different type of sanctions. And also there's an issue regarding the risk of the unlawful sanction evasion tactics by the sanctioned entities, which could also be harmful for the third parties, and therefore pressure for shipping companies to adapt and better monitor their compliance is increasing, because even though these shipping companies, if you are an Indonesian shipping companies who trade internationally, or if you have any counterparts who are trading with nationals or entities which falls under the jurisdictions of these sanctioning authorities, then it would be prudent for you to also follow the rules so that it will not affect your business as well. Can next slide, please. Yes, so we have identified the major contractual risk arising out of or in connection with the sanctions lately for our discussion today, in which, first of all, in the cases where one party is sanctioned, however, the dispute of the claims arise from the issues of contract performances or non-payment due to the sanctions. And then the second is where neither party is sanctioned, but performance is impacted by trade sanctions, prohibiting the movement of goods or performance by third party. And then the third is the issue of illegal competence or jurisdiction or arbitrability in the cases of disputes arising out of sanctions. However, the domicile or the nationality of the parties is not within the jurisdictions where the sanctions are put in place. Next slide, please. Yes. So the two major issues regarding the claims arising out of sanctions is first of all non-performance or delay of performance, or any type of actions that are affected due to sanctions in prohibiting one party to perform their contract smoothly. For example, if you have a shipment from one vessel from point A to B, however, it is the ship is arrested due to due to suspicions, or if it's found that any of the owner, charters, or even the cargo carried is among on the sanction list of under one sanction authorities, then the next question that we would have to look to is as to whether there are available legal defenses for the sanction-related issues in the particular jurisdiction, and to what extent, if any, is recognized in that jurisdiction. So, does a frustration or force majeure defense will be available in these cases, or is it considered as illegal for the contract to continue, for it to perform? And also the second issue is regarding payment. So this is more of a issue of a practicality instead of the legality of the impact of how sanctions could affect the performance of your contract. Because for example, if a bank or a party's compliance policy is more stringent and include an umbrella prohibition on transactions linked to these sanctions, then there may be an issue in smooth flow of payment even after you perform the contract, if there are sanctions related actions or parties involved. Next slide, please. Yes. So once again, how can Indonesians be affected by extraterritorial enforcement of such trade sanctions, assuming that you have no U.S. persons or any EU persons involved in the chain of your trade? So first and foremost, violations, if performed by these people under the jurisdictions of the sanction authorities, they can lead to civil enforcement action. They could lead to administrative actions like revoking business licenses, or even criminal penalties for persons or transactions. However, there are some sanctioning authorities, such as the US. In fact, they also have secondary sanctions that could even apply extraterritorial to entities outside the jurisdiction, as we can see as in the previous example that we had regarding some Asian entities or ship owners which had no direct relation to US persons at all, but still being put on the US sanctioned list because they assisted in the transfer of a trade of the sanctioned goods. So in a way, Indonesian shipping businesses can still be exposed to enforcement risk of these US persons, although this is in a business perspective, where we have not looked through the legal impact of it yet. And this is if they engage in such transactions involving, for example, if they directly trade with entities from the sanctioned countries, such as Iran, North Korea, Russia, and Venezuela, and it's directly with specially designated nationals, if it's from the US OFAC, or targeted individuals or entities. If the cargo that they are carrying is originating from or destined to embargo territories, and if they're flagged vessels or charterers subject to the sanctions. And it could also be that they use the currency like US dollar denominated transactions or US linked financial institutions, in which if you trade in sanctioned goods, or if you trade with the sanctioned entities, it may affect you too. So how can you manage your legal risks knowing all of this information? So we will guide you through the general steps, especially for owners, charters, and all stakeholders in the maritime industry, which you may want to know a practical guidance for. So first of all, we suggest that you identify who and what who are the parties and what type of sanctions, if any, would apply to any of the parties, cargoes, or activities in the contract that you have, and decide if they are among the publicly listed sanction list from the known existing sanctioning authorities. So unfortunately, there is no one comprehensive list that you can refer to all kinds of trade sanctions from each foreign policies from the world. But you can manually refer to, for example, the US list of sanctions, sanction targets, and especially the designated nationals or SDNs, consolidated list of targets and designated persons from the EU or UK, or list of published by any other specific state or organization which may be relevant to you and your organization, such as perhaps Russia's sanction for Ukraine and so forth. Next, please. And the next step would be how does it apply to you, if any, and your counterpart? So for EU sanctions, they generally apply within the territory of the EU, including its airspace. If you board any vessel under the jurisdiction of a member state, any person inside or outside the territory who is a national of a member state, and to any legal person, entity, or body in respect of any business done in whole or in part within the EU. For US sanctions, they generally apply to all US persons, as seen in the list that we have put. But also there are cases where secondary extraterritorial US sanctions may apply to non-US persons. Next, please. So here are when you should proceed with more caution, because there are risks where risky and deceptive practices to evade sanction would happen. So when you identify that you are trading in high-risk regions where such dark fleets may operate, then that means you would need to be more careful doing your due diligence when you operate your businesses. You need to not only know your customer, but also know your customer's customers, where your cargo origin is from, and where it is it going to. And then if there are some red flags that you can also monitor closely, such as the location of the vessel. If the IAS is it jumps from one place to another very quickly, then that may be a red flag as well, because of a possible manipulation. And also, if it's turned off for quite some time, there may be a need for you to investigate further, and also check the flag registrations of the vessels used, and is there a possibility that they may be using fake registrations or false flags as well. Next, please. So after we discussed the general intake of how sanctions is perceived in the international community by other jurisdictions, what about Indonesia? So as a general summary, Indonesia does not recognize or enforce any international trade sanctions as part of its domestic law. So if there are any impacts, as far as we're concerned, it is more towards a business perspective instead of the legality of those trade sanctions applicable in our own territory. However, so in Indonesian law, there is a principle of freedom of contract. Basically, it means that whatever it is that is agreed between the parties, such as long as it fulfills the requirements of the contract and it does not violate public policy, it is binding between the agreed as law between the parties, and therefore if there are breaches of the performance from the already agreed binding law between the parties in the contract, then there may be a issue of a breach of a performance, no matter why the reason was, if it's due to trade sanctions or any other reasons. However, there is also a possibility that the sanctions and embargo may be put forth as an argument by the other counterparty to put forth an argument that this is a force majeure under Indonesian law, such as, for example, again, if the vessel was detained in some other port in other countries because it was indicated as violating the sanctions under that law in that country or EU, for example, a member state, then it is still a possibility that force majeure could be evoked as a reason of a defense. So next slide, please. So here it is. So how can contract drafting in Indonesia can help you manage those risks? Because of the freedom of the principle freedom of the contract, it is best that you put in proper sanction clauses with clear definitions of the warranties, indemnities, the clear obligations of the parties in view of possibility of imposition of sanctions. Why? Because currently sanctions legislation imposed by these sanctioning authorities in the US, the EU, and other countries is often imprecisely drafted because they are very volatile in terms of they are following the global trend policy, and it differs depending on the foreign policy that is being held by the particular jurisdiction of that sanctioning authority. And thus quite unreliable and often amended. It could be taken out, it could be added at any time, which can make it quite difficult for the parties to assess whether or not a trade or activity is prohibited and not at the time of the business deal or when the contract is drafted. So to protect your best interest, it is better that you put all the proper clauses that could protect your best interests in your contracts or charter parties if possible. So what do? We suggest that you draft robust protective sanctions clauses in your charter parties, such as sanction clauses and compliance warranties. You can take samples from the already available standard forms in several standard contracts, which can also be easily accessed online, such as the BIMCO contracts like the BACON, or any and some other type of standard contracts that we will revisit later, and I will show you some examples. And then also the possibility of a force majeure or frustration or hardship provisions in case of trade sanctions, because general clauses of normal force majeure clauses, keadaan kahar, which is usually incorporated in our Indonesian contracts, may not suffice or may not be enough protection for you if something occurs in the way due to these imposing sanctions. And also clear allocation for sanction-related risks is advisable, including indemnity for non-compliance, provision addressing vessel arrests, cargo confiscations, delays, and so forth, as well as what is the notification procedures if any termination of rights is allowed due to these sanctions or non-compliance thereof. And once you incorporate all of these in your charter parties or in your contracts, we would also recommend that you also incorporate it in your bill of ladings and other relevant transport documents. Next, please. So here it is, some of the example of sanctions clause in BIMCO. So this is taken from the BIMCO sanctions clause for container vessel. The time charter part is 2021. So as we can see, there are definitions such as what is considered as a sanctioning authority, what is a sanctioning party, sanctioning cargo, and there's also regarding the warranties and indemnities as well. Next slide, please. Yes. This is also another example of a different BIMCO standard contract, which you can refer to. This is from the BIMCO GenCore sanctions clause for contracts of affreightment 2020. So the important issue of why sanction clauses is advisable is because the definition of sanctioned person, it could mean a test of ownership and control of who is actually the ultimate beneficial owner for such entity or vessel. Are they actually a sanctioned entity? Are they from a sanctioned country? And also the importance of drafting the obligations as well is who has the right to exercise the remedy if non-compliance of sanctions is found and affects the performance of the contract. And then it could also be more clear on several issues such as can a party, for example, rely on a sanctions clause if there is only a risk of breach of sanctions? Or can a party who is the one who is breaching the sanctions use termination provisions, which is already drafted in the contract, to improve their commercial position? So it is best to draft your contracts or your charter parties as robust as possible to prevent issues and questions such as this in the future. So next is, how can we help you in this regard? So as from Angraini and Partners, we have a bespoke and customized legal services which we can provide you on a case-to-case basis, which is called one-on-one legal services. So we believe that each client is special in a way, and we will be able to cater for your specific needs. So for example, one of our services that we offer is we can provide risk assessments and also compliance mapping of your already current charter parties or your future ones as well. We can also provide a review of whether or not you have a concerning trade routes in relation to the high risk voyages, or your documentation of your cargoes, your review of your counterparties, and the standard operation procedures that you already have internally in your companies, if you may, to identify potential sanctions exposure. And also, we can also definitely assist you in drafting contractual safeguards, revising the already clauses that you have in your charter parties or your future as well. Bills of lading agreements to also include sanctions protections, which we have briefly mentioned earlier. We also provide real-time advisory on demand advice for your legal concerns. And also we can also provide training and compliance culture for your operations team, legal team, or management who should be in the know for these procedures to prevent risk due to sanctions from happening or to minimize thereof. And then we could also, in the unfortunate event that you are already in the publicly listed sanctioned entity or individual, or if your vessel is put under these lists from sanctioned authorities, we could also provide you with an advice and possible assistance if we could for delisting procedures from those lists to prevent other business reputational issue or any other concerns that you may have from being put on such list. And we will once again would like to reaffirm that although this is not a legal concern as it stands, but we can also advise you in such matters from the business aspects that you may be concerned of due to this sanctioned lists as well. And so you can contact us from Angraini and Partners. We are from the Ocean Maritime Climate Team. Our managing partner, Ms. Setiawati Fitri Angraini, is on the left side, is a renowned maritime lawyer in Indonesia, which we will be very happy to also assist you with. If you have any concerns, you can email us directly to our managing partner and also to me, if you may. And also we are supported by our two amazing researchers, which is Ms. Orima Melati Devi, which you have seen a glimpse earlier, and also Ms. Alicia Daphne Anugrah as also a researcher. And you can also contact us for in-depth questions or the legal one-on-one sessions, if you may, in our general email. If you're quite a bit shy and don't want to message us personally, we will also be welcoming you with open arms. So I think that concludes my very brief presentation today. Thank you very much for being patient and listening to the material. I hope we can have a fruitful discussion regarding this matter. If you have any questions, please do let us know. If you do have very specific questions or you have any other concerns that may be outside or a bit in touch of the topic today, you can also contact us through the emails that we provided earlier, and we can also follow it with it later. Back to you, Miss Orima Devi. Thank you.
All right. Thank you. Congratulations, Miss Sigi. What an outstanding performance you did there. We're very glad to have this session, and I think it's a very invaluable experience for all of us, including myself. So just a little trigger maybe before we open the floor for everyone to have an open discussion. We still have time. I'm just curious. So one of your slides said that Indonesia doesn't really acknowledge international instruments. As a legal practitioner and also a researcher in academic field, do you think this is something that we should be concerned of, or is it really nothing that we should really be worried about, or maybe there is some elevating needed to be done? I'm just curious, and maybe you can share with us. Thank you.
So just a bit of clarification. It's not that Indonesia does not recognize international instruments, because we ratify international conventions, and also we have like multi country agreements and investment treaties, and we also bilateral treaties as well. So we do recognize these international instruments as also part of our law. However, for in terms of sanctions imposed by other jurisdictions, by foreign countries. So as we did briefly brushed it earlier, these are mostly foreign policies due to protectionist policies from that particular country, or maybe a tool for them to instead of full-on blown military aggression or a war with arms, they use tools such as trade sanctions and also maybe tariffs or other barriers for trade. So it is more like economic sanctions, hopefully being able to control the other country which they perceived as having perverse practices or trade, or maybe in any other considerations, and to eventually guide their hand towards where they want it to be. So it's more of a political form of uh, instead of how does it affect us in legal terms. So if your question is like, is this a concern for us that we are not in applying what other jurisdictions have imposed to their own nationals, and the traits of how their nationals should be carried. I don't think as a legal standpoint it would matter, but it may be a different question entirely if it's regarding a business decision or economic decision impacted due to this trade sanctions. And so this is also why the clauses regarding sanction clauses should also include a degree of flexibility to ensure that they stand up to the frequently changing geopolitical circumstances, because these sanction lists, they are not permanent 100%. They could be added today and tomorrow. They could be put off of the list if the sanction authority decides that actually they did not violate or not, they are not non-compliance to the sanction requirements, or there may be other changes to their own foreign policy. And from a business point of view, though, I do think that it may be a concerning issue, because the um, the the sanctions unilaterally imposed by these foreign countries can effectively affect the international shipping scene in general. It's because of reasons such as, first of all, shipping restrictions. Sanctions could prohibit, restrict the movement of ships from the sanctioned countries, and two, this could include like banning entry of a ship for specific ports, or use of passing through their territorial waters, for example, impose limits of goods that could be traded, and then it will affect the flow of payment as well. If, for example, the company violates the sanctions, got their assets frozen because of a uh, potential sanction entity owning a part of the cargo, and or if there is anyone involved that is actually on the entity's list of the sanctioned parties. And also at the end of the day, it will cause disruption to the supply chain in general. So it is a concern, but for my personal point of view, I think that is a more in an economic or business stance of point of view for Indonesia as it concerned, instead of its legality.
All right. Well, thank you very much. That's actually very interesting to know that there's multiple ways to see it. And maybe in one point of view, in this case, from the law side, it may not be really something to be um, concerned about, but it's another thing when you're in a business owner. So that's very great to know, Ms. Siki. And I would like to invite everyone here on the floor. If you have any questions or you would like to discuss with us, you're very welcome by raising your hand. And maybe Pak Anggi and also Daphne, if you can help me see if I'm.
Yeah, there is a guy, Mr.
Oh,
Doni.
okay, Mr. Doni, please introduce yourself and deliver your questions, please.
Good afternoon, Miss. Am I audible?
Afternoon. Yes,
Yes.
you are audible.
I'm
Thank
sorry
you.
if the background noise are so noisy. I'm in a cafeteria, so mind you.
No, it's fine.
Okay, my name
We
is
can hear you perfectly
Ragi,
well.
and I work at a startup. But our startup usually write about public policy. So yeah, it's kind of my interest in public policy and also law overall. So my question is, we talk a lot about sanctions, and as you can say that sanctions are a dynamic changes, yeah, that one country can give one sanctions on one day and then the other and then on the other day another sanctions is given by another country. So my question is, how far can sanctions be recognized as a force majeure, and are they considered as a defense if one is breaching contract because of the sanctions given to them? I'm
Mm.
sorry if am I am sorry for my nervousness. Uh,
It's okay, you're doing
are my
great.
thank you. Are my questions
Yes,
clear or
yes. No, I think I got your question. So, how far the force majeure defense could be invoked in terms of sanctions that could apply, especially if the sanctions are if the issue is there overlapping regimes of the sanctioning authorities. For example, for the US and then for the EU, they have different type of sanctions for one one country or one entity that applies at the same time. So I think this is could be a case to basis. But first of all, let me clarify that Indonesia is a civil law country. We do not have the a jurisprudence, or we do not have a case precedence. This is actually in common law countries such as in the UK, Singapore, Hong Kong. They have cases and also arbitratable cases under those common law countries regarding as to whether the defense of frustration or the force majeure could be invoked in sanction cases. However, because we do not have any case precedents, what I could tell you right now that there is a possibility that this could apply if the judge perceives it as is applicable to our cases, but we can also refer it to the cases that is currently being debated in other jurisdictions as well. So I think that is in the Indonesian perspective, that is what I can provide you with at this time. However, generally speaking, in the cases that we follow in some Singaporean and UK cases, I think it was the Lamasa Investment Limited. So this is also why we put forth of the importance of including sanction clauses in your contracts, because currently in the common law countries such as the Singapore and English courts, it is acceptable that express sanctions clauses in those laws govern in the agreement is enforceable. So there is a quite robust protection measure or tool which you can put forth already inside of your contract to protect your interests in at the beginning of your business contracts. So what I could suggest to you is, if you are concerned with how the concept of force majeure could affect your the performance of your contracts later on because of the volatility of the imposed sanctions by these countries, especially if you're, as you said, a startup who is trading internationally as well. My suggestion would be you should include robust clauses defining how and to what extent the force majeure would be applied in this situation. So, and we will be happy to discuss with you further if you do need our assistance in this regard. Would that address your concerns, Mr. Doni?
yeah, it already answered my question. Thank you, Miss
Mhm.
Tiyana. And
Thank
Thank
you.
you.
I think I saw Mr. Harry's hand raising.
Hi.
Hello.
I'm just like to respond to Mr. Donny
Mhm.
because
Oh, yes, please.
Yes, please, Mr. Harry. Are you still with us, sir?
Yes, you're still on mute?
oh, sorry.
Oh,
Okay, so
okay.
I
There we
think the proper legal analysis should be how widely or how restrictively you have drafted your sanction clause. That's, I think, the proper analysis. So this, Donny, I think the problem would be a question of bargaining power and a question of that inherent conflict between your KYC rules, your know your client rules, and the marketing department of any company. Okay, so let me explain myself. Now, first of all, bargaining power. Obviously, you want to have a sanction clause that would cover as many possibilities as possible. So you want uh, a very broad sanction clause that will cover any eventuality to protect your legal risk there. Now, at the same time, you also have a situation where there are parties in international trade who actively are looking to cover themselves. They know they are breaking the sanctions, but then they have all these legal fictions, like, for example, dummy companies, holding companies. They're routed through Singapore, they're routed to all these jurisdictions that appear clean. Now, what do you do there? Now, the inherent problem is a conflict of interest between your KYC rules, your know your client rules, versus the marketing department. Because marketing departments in every business entity wants to do out. They just want to sell. But at the same time, your other compliance people are going to say, be very careful, check them out. Why are they using a dummy company? Why are we contracting with a company that's only been incorporated less than 6 months? They have no track record. Who are they? And that is where you have that problem. So the way to approach this, Pak is really to decide for your business where you want to draw the line. Look at your bargaining position. Are you able to have a very wide, all-encompassing sanction clause? Or do you want to be on the edge and to have that flexibility, especially when you have no bargaining power against the bigger, your client, basically your client. It's your client who's going to be, who may be on the sanction list, or they may get involved in some sort of sanction. So that is where the problem is. But the good news, I have some good news. The good news is that this is a very fast evolving clause. Now, remember the time before COVID? No one, your force majeure clauses did not have anything about illnesses and pandemics and things like that. And then there were all these legal problems arising because of the COVID. Now, today, what is happening is similar to what happened in COVID. What is happening is that because of the increasing use of trade sanctions and the enforcing of these trade sanctions, companies are now sitting up and saying, I need to really have a proper sanction clause. So eventually, and when I say eventually, I mean like in the next 1 or 2 years, you probably see very good or very comprehensive sanction clauses in all these trade agreements, in charter parties, and that sort of documents, maritime documents. So that's my take on it. Back to you, Madam Moderator. Thank you very much, everyone.
Thank you very much, Mr. Harry. That's a delightful insight from you, and I hope it satisfies you, Pak Doni. And I think we still have room for one more. Any other questions? Again, Pak Anggi, if I did not see anybody raising their hands, I would need your assistant. All right. I
No
think
one.
yes, all right then. Okay, so ladies and gentlemen, and for Miss Sigi, thank you very much. That was a very good session. So before we close today's session, I would like to deliver my concluding remarks. So again, thank you, Miss Sigi, for your enlightening and comprehensive presentation. And thank you as well to all participants for your active attention and engagement. So from today's session, we have learned several important points. First is that global trade sanctions present multi-dimensional legal risks for Indonesian shipping business, including contractual disputes, payment restrictions, and extraterritorial enforcements. That sanction clauses, compliance warranties, and careful drafted force major provisions are essential tools to manage risk effectively. And that's under Indonesian law. The principle of freedom of contract enables business to craft clear and protective agreements to navigate uncertain geopolitical conditions. In short, proactive legal risk management is no longer optional. However, it is fundamental. For Indonesian stakeholders, this means that fostering a compliance culture, improving monitoring practices, and adopting forward-looking legal strategies. On behalf of Angraini and Partners, I extend my sincere thanks to our speaker, Ms. Sigi, to the organizing team, Pak Anggi and team, and to all of you for being part of this session. With that, I officially close today's webinar. Thank you, and we look forward to welcoming you in our future events. Have a great night, and bye-bye.